Good evening. This is just another public shaming of Too Dumb for Lawyer, so you can feel free to skip it, or if you want to learn more about content-based restrictions, you can stick around. Too Dumb for Lawyer posted this on a previous video and then reposted it here because he thinks he scored points, but reasonable restrictions are a part of a non-public forum analysis. Reasonable restrictions aren't part of the time, place, or manner analysis. Time, place, or manner analysis is an intermediate scrutiny analysis. The elements of that are: is it content neutral? Is it based on a significant or important government interest? Is it narrowly tailored to achieve that significant or important government interest? And finally, does it leave open ample alternative channels for communication? None of those are called a reasonable restriction. However, in the non-public forum analysis, the court asks, is the restriction reasonable? Is it a reasonable restriction? And is it viewpoint neutral? That's it. So when you ask me, or when you start off with a sentence like that, and I read reasonable restriction, I'm not going to assume that you're just horribly butchering a term and trying to, I don't know, reshape the Supreme Court's test on forum analysis. I'm going to assume that you're a retard. And that is exactly what I did. I said time, place, and manner restrictions are immediate scrutiny because you brought up reasonable restriction. And I continue with, and I highly doubt it's a manner restriction. Could be, because there's always a chance. There's a chance that the sun won't rise tomorrow. Or, that the world won't rotate, that the earth won't rotate to make it appear as though the sun was rising. Anyway. So he has somewhat modified his stance, or maybe tailored it somewhat better. You can see this is 5 hours ago. He has edited it. He's had plenty of time, even after I've come by and said wrong. Once again, I read the first sentence. I've only read the first sentence. I guess we can read the rest of it later, but we're going to deal with the first sentence. The first sentence says, the restriction as set forth by Blue Bacon, meaning Blue Bacon's misunderstanding that you can't film a military base that is a restricted area from the traditional public forum. And the sign posted, and he would be referring to, I'm assuming, this sign that says photographing or making notes, drawings, maps, or graphical representations of this area or its activities are prohibited unless specially authorized by the commander. I'm assuming those two things would be a content neutral manner restriction. No, both of those expressly reference content. He says, i.e., you can, in quotes, look at it, but you cannot, in quotes, photograph it. And see, this is just, I mean, he just displays how stupid he is. Looking is not speech. Looking is not speech. You should have said something like, you can talk about it, you can describe it with words, you can, or something, I don't know. I guess you can't do that because this does restrict you from taking notes. But looking isn't speech. So theoretically, you could be trying to make a conduct restriction argument. You could be trying to cast photography as conduct, but it's not. So I don't know. Conduct restrictions would be like the a regulation or a statute that makes it a crime to burn your draft card. If someone then burns their draft card as protest, they're using conduct as speech, and the court is going to go through an analysis of it to determine whether or not that conduct restriction is in fact a speech restriction in disguise, essentially. But no, it isn't, because photography is speech, not conduct. The courts analyze it as speech, so I don't know. It just doesn't make sense. But the real kicker is this last word, it. You can't photograph it. Well, in order to know if you're in violation of the sign or of Blue Bacon's hypothetical reading of 18 USC 795, in order to be in violation of it, you have to photograph a specific thing. You'd have to photograph the base for Blue Bacon, or you'd have to make a photograph of this area or its activities. So you could take a photograph right next to the base, right next to the restricted area under Blue Bacon's interpretation of 18 USC 795. But if you're not taking a picture of the base, let's say you're taking a picture of the sidewalk or of a sign on a lamppost that doesn't catch any part of the base in it, well, then you wouldn't be in violation. So you could be there taking pictures all day long as you're not taking pictures of the base. Again, according to Blue Bacon's interpretation, not reality. And as far as the sign is concerned, you could make notes all day long as you're not making notes of the area or its activities. You could take photographs all day long as you're not taking photographs of the area or its activities. Again, maps, notes, drawings, whatever, you could do it in that area right there as long as the content isn't the area or its activities. It is a content restriction. In order to convict you of violating this restriction, they would have to know what you took a photograph of. And if you really want to get jiggy with it, Reed versus the Town of Gilbert, a 2015 U.S. Supreme Court decision, really sets it out. In the Town of Gilbert, they had a fairly complex sign ordinance that set different standards for different signs. Political signs were treated different from religious signs, which were treated different from ideological signs, which were treated from temporary directional signs. And so Reed is the pastor of a church that didn't have a building, so they had to hold their Sunday gatherings at different places at different times, depending on what spot they can get. And so what they would do is they would put out temporary directional signs, directing people to where the service would be on that Sunday morning. Now, a temporary directional sign under the Town of Gilbert's ordinances could only be up no earlier than 12 hours before the event started, and they had to be taken down no later than 1 hour after the event concluded. And Reed couldn't really comply with that. And so this went all the way up to the Ninth Circuit Court of Appeals on a constitutional basis. The Ninth Circuit said that no, it's a content neutral. It's content neutral. You're fine. Went all the way back down on a motion to dismiss. Went all the way back up again through the Ninth Circuit Court of Appeals, and then the U.S. Supreme Court granted certiorari. And the U.S. Supreme Court said the town sign code is content-based on its face. It defines temporary directional signs on the basis of whether the sign conveys a message of directing the public to church or some other qualifying event. It defines political signs on the basis of whether a sign's message is designed to influence the outcome of an election. And it defines ideological signs on the basis of whether a sign communicates a message or ideas that do not fit with the code's other categories. It then subjects each of these categories to different restrictions. The restrictions in the sign code that apply to any given sign thus depend entirely on the communicative content of the sign. So, again, 18 U.S.C. 795, it defines what a vital military or naval installation or equipment is through Executive Order 10104. In order to understand whether or not somebody has violated 18 U.S.C. 795, you'd have to look at the Executive Order 10104 and the latest executive order that defines the various classifications, designations, or markings, which is 13526. So there are definitions for these things, and if there are definitions for what you can and can't photograph, then it is content-based. And this has a definition in it. This area or its activities. If you photograph that area or its, not in that area, but if you photograph that area or its activities, then you are in breach of this particular sign. or if you're in that area and you're making a note about that area, you're in breach. If you're making a note about something else, you're fine. So I know that not everybody is retarded as too dumb for lawyer, and I apologize for having to break this down to such, I don't know, childish levels to try to get through to speak to the lowest common denominator, but there you go. And by the way, a limited public forum is not necessarily a public forum, and public forum is not the antithesis of a non-public forum. A non-public forum, the polar opposite of a non-public forum, is a traditional public forum. A public forum could be a designated public forum. It could be a not. It could also not be a designated public forum because the government could remove the designation and it would immediately change. A limited public forum is not necessarily public. A limited public forum, if the city rents a movie theater to show or to have a political speaker come, that is a limited public forum for that night, for that purpose. Then it'll go right back to being a private theater. So, yeah, you got to be careful with words. You got to be careful with words. Words have meanings. Thanks for watching. Have a great day.